Welcome to the first of South Texans Property Rights Association's webinars on property tax. South Texans Property Rights Association was officially formed back in 2006 in Brooks County because of concerns for landowner safety, landowner liability, and property damage caused by border security and immigration issues on private property. Since then, STPRA has grown to have over 500 members with over about 5 million acres of land in South Texas that's represented by our members. And we're really privileged to have to put on this webinar today. My name is Eric Opiella, and I'm the incoming president for South Texans Property Rights Association. I'm going to tell you a little bit about STPRA, and then we'll get into our presentation with our guest, Cassie Gresham. Our current issues, of course, are still border security, immigration reform, eminent domain, which, of course, we've been fighting a battle against pipelines and power lines for the last couple of sessions, hand in hand with Cassie and some of her members and clients of her firm. Human and animal health, especially dealing with Chagas disease, which is a terrible disease. It's been spreading throughout South Texas, and working on those issues, as well as fever tick, water regulation and conservation. This issue, taxation and property taxation, this coming session is going to be an important issue, and that's why we're doing this webinar. Landowner liability, prescribed burning, transportation, and the Endangered Species Act, and landowner compensation. So a lot of issues that our organization works to advocate on behalf of South Texans for. And for those of you who aren't members of STPRA, you can join at stpra.org. Is our website, and you can learn more about the organization there. Now turning to taxation. Of course, taxation is a constant for every landowner, whether it's federal income tax or property taxes paid on the local level. It's real important to make sure your taxes are under check to make sure you can have a profitable business operation. There's a need by our membership and many other landowners in South Texas for an organized alliance to lead the effort on keeping local property taxes in check. And our board has seen that it's an opportunity for STPRA to fill that role. We plan to this year create an annual reminder that goes out to membership prior to tax season, host informational webinars such as this, and continue to search for additional resources that landowners can use to keep their property taxes under check. Part of that is building a relationship with our county appraisal districts, making sure that landowner groups and county appraisers work together to make sure that the rules are followed consistently from county to county, and also to make sure landowners are involved in committees such as the Ag Valuation Committee that's established at every county level to make sure that our ag valuations and open space valuations are appropriately valued, and make sure that that landowners have a fair shake in protesting their property taxes. Now, STPRA is not a licensed property tax consultant. We're not in the business of providing property tax consulting services. And we encourage our members and others to seek their own counsel from people like Cassie with regard to property tax protest basis, deadlines, and procedures. That's not what we're doing as an organization, but we're trying to inform you so that you can effectively protest and keep your valuations in a fair and equitable manner. And of course, we ask that anyone who isn't a member to become a member of STPRA. We have a voice up at the legislature. We're involved every session with the legislature, allied with other landowner groups, to make sure that South Texas landowners' voices are represented before our legislature, and also with our federal elected officials as well. We host regional conferences. Now, this year, we put a lot of that online because of COVID. So these webinars will be available by a link on our website. We're recording this webinar. If you have any questions during it, you can use the Q&A function that is located at the bottom of your screen if you're watching this, and put it in the chat box, or in the Q&A box in particular, not the chat box, the Q&A box, and we'll answer those questions throughout the presentation or at the end. If you want to hold your questions to the end, that's fine too. We also have a website that is available to learn more about not only property taxation, but any of our topics of interest. So Without further ado, I want to introduce Cassie Gresham. She's a principal attorney and counselor for Braun and Gresham law firm up in the hill country of Texas. Landowners come to Cassie because of her unrelenting dedication to protecting their rights. Cassie helps her clients identify their needs and find right solutions for them concerning property taxes, buying and selling property, boundary disputes, and conservation and condemnation issues. She's represented her clients' interest in county and district courts, as well as before various appraisal review boards across the state. Her determination and skill in working with various governmental agencies and nonprofit entities has helped Cassie earn her reputation as an outstanding client advocate. She's been very involved at the legislature in making sure that our open space valuations are protected and preserved. She's also represented a bunch of landowners in those issues. And full disclosure, I'm a client of her firm. And I'm an attorney as well. So that's an endorsement right there. But nevertheless, she is a great advocate for landowners, and we're honored to have her give this presentation in a very timely fashion. At the end of this year, there's a lot of steps that landowners can take to ensure that their open space valuations are not put in jeopardy. The look back date is always January 1st for valuations in this state. And so there's some steps that you can take as landowners right now to make sure that you don't put your ag valuation in jeopardy. And that is the topic of our presentation today. So I'll hand it over to Cassie. Thank you so much for being here.
Great. Thanks so much, Eric. I look forward to the presentation and also, any questions. So feel free to pepper us with questions. That'll make the presentation much more interesting. And our organization at Braun and Gresham, we've worked with South Texas Property Rights Association for a number of years now, and they do a great job of educating their members and advocating at the legislature. So we really enjoy that partnership. So let's get. I'm just going to give you we're going to talk about ag use and wildlife today, and the requirements of what you need to do before the beginning of the year, and some, I would say, some pitfalls, some things I see that landowners will mess up or not do exactly right, and the problems I usually have to solve. So ag under a 1D1, which is under the Texas Constitution, is under this section of the tax code. Qualified open space, ag is defined as qualified open space land means land that is currently devoted principally to agricultural use to the degree of intensity generally accepted in the area. That's the legal requirement. That's what the statute says. So Eric, go to the next slide, and I think we break that down a little bit. So if you take that definition and break it down into its parts, the first is, what does principal use mean? And different appraisal districts have different views of principal use, but most of them think of, how is the property being used as of January 1 of the year in which you're applying? So ag applications are due April 30th or May 1st is really the deadline by statute. And but the appraisal district does what Eric was describing as a look back. How was the property being used as of January 1? Did it have agricultural use? Did it have cows on the property? Were they working on their fences? Were there crops being planted? I know January 1 isn't a season for planting, but what are you doing to prepare for the season of planting? And so principal use is one of the primary issues that a landowner has to make sure. You don't want to, one thing that appraisal districts might look at is if you've only put your cows on the property or have livestock on the property in June, then the principal use of the property as of January 1 may not have been for ag. And then the second requirement is degree of intensity generally accepted in the area, which is absolutely not defined in the statute. And you have to look to other places in the law or other guidelines for what that means. And it's kind of a confusing term. So we typically look at the the ag manual that's put forth by the comptroller's office. But really, degree of intensity only affects the year in which you're applying. So let's say you are making an ag application in 2021, they would look at, well, what is the degree of intensity? What have you done in that year that is typical of other landowners in your county? So that can be number of animal units. So they may look and say, well, in Brooks County, a typical rancher would have X number of cattle on their property, and that's going to be the degree of intensity. Also, each individual appraisal district should have an ag board, an agricultural board that they consult with about what are the typical practices for this particular county. And sometimes the appraisal district will send out surveys to survey ag landowners about how they're using, and they use that information to set those degree of intensity. The comptroller also says that to determine degree of intensity, you look at the labor, equipment, management, and capital that's being invested into a particular ag enterprise. So I had a case a few years ago in Gillespie County, which is where Fredericksburg is located, and we were taught, this was a horse grazing case. So the appraisal district was saying, well, you can't qualify properties for grazing horses if they're just grazing, and the law is that you actually can graze horses on your property as long as you're not using them for recreational use. And one of the things we presented to the jury was the labor that the landowner did on the property, the planting of the seed and the labor that they did to grow the grass that the horses were grazing on. So they can often look at, are you doing the similar amount of labor as another ag user in your county? So I talked about number of animal units, and then they also look at types and seasons for crops. So, you know, there's certain times of year that you're going to plant hay, or certain times of year that you're going to plant cotton or soybeans or corn. And if you're planting that in January, then you're likely not going to get a crop. And so it is typical that you would do that at typical times of year, but you may be doing things to prepare the soil. Are you tilling it? Are you turning it over? What are you doing to get your property ready? Again, they often look, it's county specific. What are the common practices within your county for ag use? Let's go to the next one. This was an interesting, this is not a direct quote from because I kind of explained it a little bit more, but because degree of intensity is not defined in the law, the manual for the appraisal of agricultural land is put out by the comptroller's office to give some guidelines. It is not statute, but it is really the Bible by which appraisal districts should be acting upon. And the manual says the land must be currently devoted to agricultural use. The land must qualify on January 1st. But if use is not evidenced in January, then the application should be granted. This is from the Ag Appraisal Manual. If the owner can show evidence of the intent to put the land into ag use, and that ag use will be the primary use for the bulk of that calendar year. So this is some guidance that's given by the comptroller. Again, this is unfortunately very murky. It's hard for landowners to know what is the bulk of the calendar year. Sometimes appraisal districts think that's 6 months in a year, in a day, and that would be considered bulk of the calendar year. And what is show evidence of the intent to put land into ag use? Well, I think that a lease. So let's say that you had your agricultural lease and it was signed as of January 1, and it showed that your lessee was going to use your property, then I think that would show evidence of the intent. Maybe the animals aren't there yet, but they're coming. And you could show, well, you know, my ag lease was there. I really encourage landowners to get your agricultural leases in writing and make sure that you understand the animal units that your lessee is going to put on your property, and make sure that they they meet the requirements of the appraisal district, because that is really your responsibility as the owner of the property. Let's see. Okay, so wildlife management, a little different. This is a type of ag use. As you guys probably know, you have to have a qualified open space valuation. So that means agricultural use or timber ecolab before you can qualify for wildlife. But wildlife is defined as actively using land at the time the wildlife management use began, and it was appraised as open space land in at least 3 of the following ways. So I didn't list all the, it's a big long section of the code, but you have to manage your property for wildlife using 3 different wildlife management practices. And as long as you're doing 3 different wildlife management practices on your property in the 7 different categories, then you can qualify your property. They do not have to be implemented as of January 1, because they also are seasonal. But I think showing the appraisal district that as of January 1, you've got a plan, you're moving towards your wildlife management, you're starting to actively use the land for wildlife is really important. So I mentioned this before. One of the big requirements of wildlife management, the way it was set up in 1995, is that you have to have qualified open space valuation in the previous year. So there are 3 different ways to have that qualified open space. Ag is the traditional one. Ecolab, sometimes landowners use that. And timber, which doesn't happen in South Texas, but and not in the hill country either, but in East Texas, you can have a timber valuation and move into wildlife. And again, the question is, what is principal use of the property for wildlife management mean? And the comptroller's guidelines say that you don't have to implement the practices year-round, and it's not even necessary that you start them on January 1, but it kind of depends on what practices you're implementing on the property. So for instance, the best case scenario, if you're going from ag to wildlife management, if you wanted to cross your T's and dot your I's, would be you would, as of January 1, have a wildlife management plan in place, and you would have maybe done some activities before January 1. Maybe you did a breeding bird census prior to January 1. I said a breeding bird census, a wintering bird census, sorry. The breeding birds are in the spring. Wintering can occur around Christmas time, so a lot of landowners will do that. That's one way you can show, well, as of January 1, I was using my property for wildlife. Maybe doing some brush management might also show that. Again, not a hard and fast rule, but I think as a good rule of thumb, most appraisal districts, when you are submitting your wildlife management plan by that May 1st deadline, every year, they want to know that you've started to implement. And if you can demonstrate, hey, I'm going to do 5 practices, or I'm going to do these 3, and I've done one already, I think that shows the appraisal district your intent to actively use your property for wildlife. So the next 2 slides are kind of common pitfalls. Where do I see the most problems? You know, honestly, and yesterday I was writing a blog about this. I'm going to do a blog in the new year about common pitfalls for open space valuations. And the number one pitfall I see is not understanding your local appraisal district requirements. So the best advice I could give to landowners is make sure you know your ag appraiser that's in your county. Pick up the phone, call them, be in constant communication. Find out what animal units they require for ag. Have a conversation with them about your particular property. Find out, what, I know this is crazy, but, in a few years ago in Bastrop County, the ag appraiser has now changed, but it was David Ballard, and he told me, well, I know it's not a requirement in the law, but I require a census. I want to see a census, either of animals or birds, in order to qualify all of our properties for wildlife management. Because how can you know what you're managing on your property unless you have a census? Well, no one would know that that was a requirement. That certainly is outside of the law, that he can make that requirement. But if you're talking to him, you would know, hey, David, what do you want to see? What do you like to see? So I think having a personal relationship with your ag appraiser, understanding what they want to see is really important. I had in Travis County, year before last, the ag appraiser changed, and I had dozens of landowners. And when the ag appraiser changed, the deadline to file annual reports changed. So it went from May was the normal deadline under the old ag appraiser to February. And my clients had been filing May annual reports every year for 10 years under the old ag appraiser. And the new ag appraiser comes in and she moves it up till February and sends out a letter and notifies everyone. But a lot of the Travis County landowners were expecting a May annual report and they missed it. And she denied them that year because they had missed that deadline, even though they were doing all of their wildlife management valuation activities in accordance with the law. So if you're having communications with the ag appraiser or in the wildlife management appraiser, then you know if those deadlines are changing. I also would tell you, make sure that I would just tell landowners, check in on an annual basis, and I would do it in April, so that you're saying, hey, is everything good with my property? It can be a quick email. Do I need to be doing anything? That would allow you to know, did I miss a notice? Because under the law, they're only required to put that notice in the mail. They are not required to make sure you receive it. And it has been especially difficult in this COVID year, where I actually had clients get a notification from the post office that they had something that needed to be picked up. They asked for it to be redelivered a couple of times and they never got the notice, and they missed their deadline to protest. And the appraisal district stuck by the deadline, even though we could demonstrate, we attempted to have it delivered and we never got it. So you definitely need to be in communication, I would call them. I'll get off my soapbox there, but I think that's like the number one thing that you can do. Are there different requirements in a qualifying year versus a non-qualifying year? So what that means is, if you're coming in and trying to qualify, you're in your ag use, you've done 5 years of history and you're coming in year 6 and this is your qualifying year. Or you're moving from ag to wildlife management and this is your qualifying year. I would say there could be difference between your qualifying year versus your non-qualifying year, in that, again, going to the crossing your T's, dotting your I's, if you're qualifying for wildlife management in 2021, then I think you need to have a plan in place and you're ready to move forward, and maybe you've implemented a practice. Or if you're qualifying in 2021 for the first time for ag, maybe you want to have that ag lease signed and dated prior to January 1. So you say, look, I had the intent. We are moving forward. The cows are going on either in January or February. I'm going to have those on for the bulk of the year. There's some things that you might want to do in your qualifying year, because in your every year subsequent to that, you can document that you've been doing those activities and that it's year round. And so there could be some appraisal districts might view a qualifying year differently. Anytime they're asking for an application, you're going to get more scrutiny of your activities. So another common pitfall is whether or not there was a change in ownership. And most landowners think, well, I didn't sell any property, but let's say you did some estate planning or moved your property to an LLC or moved your property to a trust. That is a change in ownership, and it requires a new application for ag and wildlife, ecolab, timber. It requires a new application. So make sure that you're reapplying if there's been any sort of change in ownership. All right, next slide. This is a common pitfall for documenting history of use is a common pitfall for properties that are being purchased. It's often that I have a landowner come in, and if I'm representing a buyer on a real estate deal, I'm going to make sure that I've done my due diligence. When my client's purchasing the property, we're going to ask for, show us your history of use, show us your lease, tell us how many cows you've had on the property. Because what often happens when someone is selling a property, they will remove the cattle off the property, or they won't do their wildlife management activities because they're and they will say, well, it qualified in years past. It'll have on the listing, it has an open space valuation. So I would make sure that before you close, you've done your due diligence. It's part of your package. You can document the history of use so that when you're applying in your own name in the following year, you have that documentation and you're not having to go back to the seller and ask for that. And you should push back on the seller of saying, show me your lease, tell me how many animal units, can I talk to your lessee, those kind of things. And those are really important to be able to show. I mentioned this before. I think you should have a written lease in place for 2021. There's a lot of landowners who do things on a handshake. And I was dealing with an elderly client this year, and she's had the same lessee for a number of years. And she didn't know how many animal units were on the property and whether or not she qualified with the appraisal district. And she was elderly, so she was depending on the lessee to do that. And her ag got removed this year because a developer next door tore down her fence and they had to remove the cattle. Well, of course, the appraisal district comes out the week that the cattle's moved, and you know, she didn't have any documentation that she actually had a lease, and we've had to do affidavits and document subsequently. But it's very important that you've got a lease, that you understand how many animal units are going to be on the property or what crops are going to be grown or those kind of things. A lot of people, I will say, some landowners, you know, will decide to move to wildlife management because they have a little bit more control over how their property is being managed. Sometimes they if they're if they're not living on the property, then that gives them a little bit more control over that. This number 6 is, are there any changes to your land where you should notify the appraisal district? You know, this might be, hey, my neighbor and I resolved this boundary dispute and I ended up adding a ½ acre to my property this year, or I built a house on my property and I have an acre that needs to be carved out, or I put up a barn, or this actually moved from Houston to the ranch, and the ranch is now going to be my homestead. So you would still qualify for ag on the remaining acres around your property, but maybe you want to designate 1 acre where the house is for your homestead. So just be thinking each year, is there anything that's happened on my land in the last year where I need to notify the appraisal district that something has changed and kind of true up, in other words, what's happening on the property. What you don't want them to do is find out from your neighbor or an aerial view of the property that something's changed there. I really recommend that landowners be proactive in their communication and honest about what they're doing on the property. All right. This is just our Braun and Gresham is the law firm that I work for, but Plateau and Plateau Land Group are our sister companies, and they do a lot of wildlife management for landowners. Plateau Land Group's a real estate company, and we represent owners of rural land and have a lot of fun doing that, and it's a really fun, interesting practice. And property tax is one part of that I really enjoy. So, Eric, I'll be quiet and see if there's any questions.
Well, if you want to ask questions, you can put them in the Q&A box or the chat box as well. It looks like I do have access to the chat box for this presentation. We don't have the ability on a webinar to ask your questions via audio. So if you are joining by phone, unfortunately, you cannot ask questions without being logged in. But we do have, I believe, 28, 30 people who are on the video right now. So the bulk of you should be able to ask your questions either via the chat or the Q&A. On the screen right now, there's a newsletter that Cassie puts out called the Landowner Alert System. And this is, I think she talked about earlier, a blog post that she's doing. This newsletter goes out on a monthly basis and is a good way to keep apprised of developments, either in court cases or the legislature, regarding a variety of landowner issues. And you can subscribe at www.braungresham.com/subscribe. Also, here is Cassie's contact information if you want to reach her. I'll leave this screen up for a moment so you can get that information down. Bill Guerra, while people are writing that down, Bill Guerra asks, where can you find the requirements for wildlife valuation? And that's a pretty appropriate question given the fact that, well, there's 254 appraisal districts in this. So, Cassie, why don't you answer that question?
Yeah, so first, Bill, I would say there's requirements in the statute. So if you look at the law sets out 7 different categories of wildlife management, and that is kind of the legal precedent. But what the legislature did was asked the Texas Parks and Wildlife to actually adopt guidelines. And so I think there are 7, correct me if I'm wrong, Eric, but 7 different ecoregions in Texas, maybe 8, but there's different ecoregions, and then Texas Parks and Wildlife for each region has developed wildlife management practices that could be implemented for those properties within the ecoregion. So like the Hill Countries is the Edwards Plateau, and it lists 52 different wildlife management practices that can be implemented by a landowner. So Texas Parks and Wildlife has a lot of great resources there and guidelines for the types of wildlife management practices that will qualify in your particular region. Sometimes, depending on the appraisal district, your own individual appraisal district might have wildlife management guidelines or guidelines that they recommend, and it all depends on your appraisal district. I will say I do recommend that you do what your local appraisal district asks you to do, but sometimes, as I was telling the story before, appraisal districts will recommend things that are or make a decision on the law that is really outside of their purview. So you should just be aware of that. Gillespie County is a great example of their guidelines said you can't graze horses and have that qualify as an ag use, when clearly the statute and the comptroller's guidelines said differently. And so just be aware that sometimes that your local appraisal district's interpretation may be wrong. So.
Yeah, and I put up on the screen the Texas Parks and Wildlife website, which has the resources for technical guidance that you can reach out to them and give you technical guidance, as well as their details on property tax conversion for wildlife management. You can go to their website as well at tpwd.texas.gov, and you can look up that information.
They really have a great resource, and we often recommend landowners go there. And there also should be within your each region should have a biologist that works for Texas Parks and Wildlife that can advise landowners. They can't get to every landowner. That's why there's groups like Plateau that help landowners. But But there's definitely a governmental resource that's there that can advise landowners on what can qualify as well.
Okay. Our next question is from Robin Kennedy. You don't have to apply every year if you've had ag use for a number of years, do you?
You don't. I would always check in with the appraisal district. That was what I was saying. Even if it's not a reapplication year for you, just to make sure everything's good and they don't need anything from you. But typically, what happens in appraisal districts is every third or fourth year, they will divide up the county and they may ask for a reapplication. And it's not based upon anything the landowner's done. They may just divide up a zip code or an area, a fourth of the county, they'll ask for reapplication, but they're required to ask you for that, and you don't have to apply every year. And in fact, some very rural appraisal districts don't do that very often. They just assume that landowner's moving forward with ag. They do inspections. So and they typically do those in the fall. So they will be driving down the highway, and if they don't see any animals, then they might ask you to reapply so that they're establishing what's there, or they might ask for an inspection of your property. But they do site checks, and those are random when they do those. Or sometimes it's because a neighbor has reported. Appraisal districts get a lot of their fact checking from nosy neighbors that have told, hey, my neighbor's getting an ag valuation, but he's not doing anything out on his property. I've also heard that from ag appraisers as well.
So Charles Maley asks, in many urban and suburban counties, degree of use tends toward overuse or abuse of pasture resources, grazing into the dirt, essentially. Yeah. How can a landowner be a good steward in the face of this type of pressure? And also talk about the appraisal districts and how perhaps their animal units for intensity of use might conflict with what reality is on the ground, and how we can try to help that situation.
It is totally, it is such a tension between their wanting to make sure that a landowner is doing enough to qualify for the ag valuation. These are, a lot of times the ag appraisers are appraisers by training, and not they don't have training in land management or agricultural use. So I would say first, if there is an ag board, going to your local ag board and advocating for what those animal units should be based upon the conditions. And this changes on a yearly basis, right? So, some years we're in drought and the animal units need to be reduced. There is an exception for areas of Texas that are in drought. The governor puts out on a monthly basis if there's areas of Texas that are in drought, and you can rely on that to remove your cattle off your property for a period of time. There's also an ability to rest your land for 2 years. So, availing yourself of those things. I have found that sometimes, depending on the local office, that the NRCS might have better guidelines for grazing and planting and those kind of things, that, getting your local agent to go in and advocate for what the animal units might be a good choice as well.
And always document, if you're relying on advice from NRCS, have them send you an email that says, my advice based upon the current conditions is that your land has a current carrying capacity of X number of animals per acre. That's always.
I agree with that. And I actually would send that to the appraisal district, be proactive. So once you get that advice, say, this is what I'm doing on my property. Is this okay? Be proactive in your conversations with the appraisal district, because you want to know, so that you can make adjustments. So often I will tell landowners, communicate, send an email to that ag appraiser and say, hey, this is what's going on my land. Is this okay? And documenting their response is important.
Always think about anything you do could be the subject of litigation in the future, right?
Yeah.
And always make sure that you want to put your best foot forward as soon as possible. If you let the appraisal district know this is what I intend to do and they don't respond, they have a much harder time arguing that their position is reasonable.
Yeah,
They didn't notify you that that was going to be their position.
well, and the appraisal review board, I think, will be more sympathetic to a landowner who said, I tried to communicate, I told them what I was doing, I got no response. And so I definitely recommend that. And, I have found that, especially during COVID times, an email is a lot easier for them to answer because they're not always in the office. Depending on the appraisal district, some of them are not taking in person, they're not at the office, but they are answering emails. And it gives you a way to document, hey, I sent this on this date. They received it. Letters are still good, but sometimes they're not as quick to respond. You can show that you sent it with a green card, but they may not respond immediately. So email's a great way to do that.
And also know that appraisal districts are not required to send all notices by certified mail. So anything that has your appraisal district's name on it in the envelope, make sure that it gets opened, because it could be something important that you need to know. Tom
Yeah.
Kasur asks, does the 1D1 have to be revised for any minor changes in wildlife activities, such as type of wildlife, seed planted, etc.?
I think what you're asking, Tom, is do you need to change your plan in if you're changing the type of seed? I don't think so. I think that your wildlife management plan is laying out the things that you have planned to do, but those might change. So I would say over, every 5 years, you might look at that plan. And even if your appraisal district is not asking you to resubmit it, you might look at it and make sure that, hey, the plan that I have, does it reflect what I'm actually doing on the property, or have I started to do some different things and I need to update my plan? But I would say, as long as you're doing 3 wildlife management activities on your property, then you're okay. And changing the seed or getting better techniques, I think is fine.
Talking about communication, though, Cassie, would it be a good idea that if you do change the technique, that you update your plan and then send that to the appraisal district?
I think that, I mean, I know that's a lot of work for landowners and maybe overkill, but I see no harm in emailing them and, a new plan, sending in and say, hey, I changed this thing, or last year, you don't have to do it on a monthly basis, but, maybe you look at it and say, I really should tell them that I'm doing this one thing differently. One thing I would recommend is, when you're talking to them, really understand, most appraisal districts are not asking for annual reports every year. It's mostly the urban counties that are doing that. And so kind of a gotcha has been, appraisal district can ask for an annual report at any time. And if they're not asking it for on an annual basis, and a landowner's not documenting the wildlife management activities that they're doing, it can kind of come as a surprise when you're getting a request for an annual report from your local appraisal district and you've done the activities, but you haven't really documented them. So understand your local appraisal district's requirements of how they would like to see the documentation. And maybe it's, a map that they want to see where you've implemented the things, or there's certain types of pictures that they want to see. I have have had the experience where my landowner client got their wildlife management denied based upon an annual report that they submitted, And then I took it and juiced it up a little bit and put it in a format that I knew that the ag appraiser wanted to see, and it was approved. So sometimes it's just personality, of knowing what they want to see and having worked enough with them that it can. That's not great for landowners, but it's understanding the system and knowing what your particular ag appraiser or wildlife manager appraiser wants to see.
And I think that's one of the challenges that landowners face is that, unfortunately, our laws are not supposed to be personality driven. They're,
Right.
they're supposed to be consistently applied, and you're supposed to be able to have foreknowledge of what your requirements are. It's part of due process. And why don't you talk a little bit about kind of the challenges that landowners face and maybe some legislative changes that need to be addressed by the legislature going forward?
Yeah, Eric, we've talked a lot about this, and it's a frustration as somebody who advocates for landowners and represents landowners in front of the appraisal review board. The deck is definitely stacked against landowners. Legislatively, the legislature has done a few things to make that a little bit easier in the last couple of years. I'm particularly happy with the additional notice that was put into the law in 2015 for landowners that are over 65. It could use some tweaks, but what it does is require if the chief appraiser is going to remove an ag valuation from a landowner who's over 65, they have to send notice via certified mail, and they have to follow up to make sure that that landowner got it. Most appraisal districts aren't aware of that notice, but it's something landowners should know about, because if you have an owner, which happens a lot with landowners, where they have lots of elderly couples, or a widow whose husband was handling it all for her, and all of a sudden she's trying to handle it and she doesn't really understand the notices that she's getting in the mail. And so there are some safeguards for elderly folks that the legislature has put in place that I think are helpful. But otherwise, it can be a county by county. It often is a county by county implementation, and it is very frustrating from the landowner side. And I think that there are, when the legislature allows the appraisal districts to set their own rules and guidelines, which is by statute, then that creates a lot of problems for applying the law equally and allowing them to do that. I think that there could be a lot more regulatory in that if you're at a landowner, you call the comptroller's office and say, hey, my local appraisal district is doing this crazy thing, they don't do anything about it. They'll just say, yeah, sorry that's happening to you, here's where the guidelines are. So there should be a lot more guidance from the state level, both from Texas Parks and Wildlife and the comptroller. Years ago, Texas Parks and Wildlife, there were a few counties that were causing some problems in the hill country, and they actually went and held seminars in those counties. They've shied away from doing that recently, but sometimes it takes just some guidance from the state level. I think more hand-holding. In the Texas Parks and Wildlife and the comptroller's office have started to make tweaks to the rules. That's why you see the ag manual had not been updated since 1990. Between 1990 and then they updated it in 2019, 2018, 2019, and then again in 2020. And there were some key case law that had changed, and some key things that had that needed to be changed in the rules that were not tracking the case law. So I would say there's a lot of tweaks that can be made on an agency basis to provide more leadership. And maybe it's more training for the ag. what we typically see is a lot of appraisal districts will have an ag appraiser or a wildlife management appraiser that moves from commercial real estate or residential real estate, and their training is not on land management, it's on appraisal. And they're asked to review and implement wildlife management techniques. And they seem to have an attitude that landowners are tax cheats. And so they come to it from a very defensive place. So I don't know if the legislature can do anything about that, but that's one of the biggest problems we have. So.
Good. I know we talked about at the beginning of this webinar the important date of January 1st. Can you talk a little bit more about that? And then what other important dates are there in the year? When do you need to be looking for taking action to protect your open space?
So I'll just make one little, if you guys, I put together, I'm sending it out to all my clients. So your members wouldn't get it unless they were my clients, but we've actually come up with a property tax calendar. So if you want to receive that, it's just something you could print out. Be sure to email me. I'll be happy to share that with everybody. But the January 1 date is where you establish the use going forward. What is your primary use as of January 1? How are you using the property? And you can have your wildlife management practices started if you're going to be applying in the year, or if you have an ag valuation, I recommend having your written lease ready to go as of January 1. Other important dates are if you are disputing your property taxes, if you have either a lawsuit or a property tax protest that is still being in the process of being resolved, you still need to pay your taxes by January 31st. And you have the choice of paying the undisputed amount or what you paid last year in taxes, or you can pay the full amount and get reimbursed. But I get that question a lot of, how much taxes do I owe? You want to pay that amount, the undisputed amount, because if you don't, then your taxes are deemed delinquent, and then your opportunity to get your protest resolved or your lawsuit resolved goes away. So I had a great example. I had a landowner whose wildlife management was removed in the previous year. She had protested. It was a late protest. It was due to lack of notice. She never got the notice from the appraisal district. And it took a year for her. So she protested in November of 2019, and we got her hearing in September of 2020. So almost a year later. And when we walked into that ARB hearing, the first thing they asked was, did she pay her taxes on time? Because they will throw you out if you haven't. And I didn't, we kind of on the fly were like, yeah, here's the statement. I did pay it on time. Here's what I paid. And I paid the undisputed amount, the ag amount. And her proceeding was allowed to go forward. But in that moment, she had to prove that she had paid them on time. So January 31st, if you have announced, you should pay them anyway, so they're not delinquent. But if you have an outstanding protest, you need to pay your taxes. Then appraisal districts typically ask for annual reports sometime in the spring. So I would check in with your local appraisal district just to see if they're asking for annual reports or if there's anything on your property. The applications are due by, we say April 30th, it's really May 1st, but it needs to be postmarked by that deadline. Your notices of appraised value are going to come out sometime in April or May, and what you're looking for there is, does it have the correct market value? Does it reflect your ag valuation? And sometimes appraisal districts on those notice of appraised value, that's their notice to you. that is considered their letter of a change in use. They sometimes just rely on the notice of appraised value. So it's really important that you're reviewing that and looking at it and protesting 30 days from the date that you received that. And also there's a statutory deadline of May 15th for protests. So it's either whichever's later. So if it's you have until May 15th to protest, or you have 30 days after you receive a notice, whichever's later. I just, we handle hundreds of clients, and we always just file a protest, and then work our way out of it. And so that we don't miss any deadlines. The other, you can, if you get into a bind, you can also file a late application for ag or wildlife, and you can usually do that before the end of July. It's usually somewhere around July 20th or something like that. And then your late application will be considered timely with a 10% penalty, but it still would be within the year. And then, you're getting your tax bills in the fall. So most of the protests have been resolved, usually in a non-COVID year by October when you're getting your tax bill, but you want to make sure that you're reviewing it and everything looks good. So that's kind of and then you start back in January 1, but that's kind of the calendar year.
Taxes are a never-ending full-year enterprise, aren't they? Unfortunately,
They are, and it used to be that all the ARB hearings were like in the summer, and you got them out of the way, and it was really intense, and they're back to back. But the last couple of years, in the more busy appraisal districts, and also just due to COVID, they've been dragging out. I've still got some hearings that need to get set that I protested, last summer.
well, one last, and this is actually not a question, but a thank you. Justin Gerbilis writes, thanks for the presentation, and informs us that Texas Parks and Wildlife has been working with AgriLife Extension to host multiple wildlife tax valuation trainings every year, specifically for appraisal district staff around the state over the last 4 years. So that's great news to
Yes.
try to make sure that the staff, this is not always an adversarial relationship. It shouldn't be, right? Everybody should want the appraisal district staff to know how to properly apply the law, so that everyone can work together to follow the law. And so this is great that Texas Parks and Wildlife has been working to educate appraisal district staff. Keep in mind, a lot of these appraisal districts are just 1 or 2 or 4 people. They're not the big Taj Mahal type enterprises you might have in some of your nice urban counties, but it is important that they get educated. Go ahead, Cassie.
That is so true. And picking up the phone and calling them and figuring out, what's going on and doing that early is super important. And we do that a lot, where we're just communicating, and they have a very big job. And it doesn't necessarily, I've learned, through the years that wearing my big legal hat doesn't help me any, when I'm calling in. And so often I will have, when I'm talking to landowners, I'll often have the landowner call, and establish that relationship and find out the information, rather than having a lawyer. Sometimes that can be intimidating. But I also know, in my experience, there's only a few law firms or lawyers that do property tax work for appraisal districts. So I know a lot of them. And I was able to resolve a chief appraiser was just this past summer was just stymied. He couldn't, I was asking him questions, and he couldn't, he wasn't sure how to respond. It was the first type of application that he had seen. And finally I just said, hey, can I talk to your lawyer? And that really helped, because he was like, yes, please. And so sometimes if you can get to someone who has a broader view, that can help too.
Well, thank you so much, Cassie, for being with us today. It's a great kickoff to our webinars for 2021. We really appreciate your time, and it is unfortunate, like one of our panelists or one of our attendees just said, that urban counties there might not be anyone that has ag background that is at the appraisal district. Well, unfortunately, as a person involved in agriculture or involved in wildlife management, it unfortunately probably falls to us to educate them as well. And so it is important that not only is Texas Parks and Wildlife helping to educate the appraisal district staff, but the role that us as landowners play in making sure that they're educated and that we work together to ensure that we keep our open space in Texas open space. That's what this is all about. This is why the legislature enacted these special valuations, is to ensure that Texas isn't paved over in concrete at the end of the day, that our future generations have the ability to have open space to be able to not only enjoy, but also help the environment as well here in Texas. So thank you so much, Cassie, and thank you all for joining us as well. Like I said at the beginning, you can go to our website at stpra.org or contact Cassie directly if you need some advice on your own land. Thank you so much, and y'all have a great day.
Thank you, Eric. Bye-bye.